Welcome to bongosikha aspirants. Today I am going to discuss the Attorney General of India first, then the Advocate General of the state. So first I am going to discuss about the Attorney General of the India, because earlier I have discussed the Comptroller and Auditor General of India, and through these three chapters, that the Comptroller and Auditor General of India, Attorney General of India and the Advocate General of the state, including these three chapters, combined questions comes in the prelims. So these three are very important. You have to read all three. The Constitution, Article 76, deals with the provision of the office of the Attorney General of India. He is the highest law officer in India. Now, the Attorney General is appointed by the President, and he should possess the qualification that he can be a judge of the Supreme Court. In other words, he should be a citizen of India. He should have been an advocate. He may be an advocate for any high court for 10 years. He may be a judge of any court for 5 years. He may be an eminent jurist in the opinion of the President. So this is the conditions, and term of the Attorney General is not fixed by the Constitution. There is no fixed provision in the Constitution regarding the term, regarding the tenure of the Attorney General. And further, the Constitution does not prescribe any procedures or any rules regarding the removal of the Attorney General. So the Attorney General can be removed by the President, or he may resign by writing a letter to the President. And normally the Attorney General resigns when the Council of Ministers resigns or the government is replaced, because he is appointed by its recommendation. So this is the one thing, the term. Then the remuneration of the Attorney General is also not fixed by the Constitution. His remuneration is determined by the President. Next, the duties and the functions. Duties and functions. As the Chief Law Officer of the country, the Attorney General holds certain important functions. What are those? That is to give the advice to the government of India on such cases which are referred to him by the President. Next, to perform such other duties of a legal character which are conferred to him by the Constitution, by the President. Next, to discharge the duties which are conferred to him by the President or any other law. So these are the functions of the Attorney General. Now the rights. In the performance of his official duties, the Attorney General has the right of audience in all courts throughout the country, and he has the right to speak, to take part in the proceedings of the either house of the Parliament, or in the joint session, or in the any proceedings of any house of which he is a member, but not entitled to vote. He enjoys all the privileges and immunities which are available to a member of the Parliament. So that is the Attorney General. Now these are the rights, or what are the facilities enjoyed by the Attorney General. But now next I am coming to the limitations which are placed upon the position of the Attorney General of India, that he should not advise. He should not advise or hold any brief against the government of India. He should not, he should not advise, or he should not hold a brief on such matters which in which he may be called upon to appear for the government of India, and he cannot give any benefits to the criminal accused of the criminal prosecutions without the permission of the government of India. And next, that he cannot accept any offer as a director of any commission without the permission of the government of India. So these are the limitations, and he should not advise any ministry. He should not advise any department of government of India, any statutory organization or any public sector undertakings under the government of India unless any reference is coming from the Department of Legal Affairs, Ministry of Law and Justice. So these are the limitations on the working of the Attorney General of India. Next, the Solicitor General of India. In addition to the Attorney General of India, there are other law officers of the government of India who will assist the Attorney General. They are the Solicitor General and the Additional Solicitor General of India. The Constitution does not make any provision regarding the office of the Solicitor General and the Additional Solicitor General here, and they didn't mention any removal procedure or any qualifications for them. It should be noted here that only office of the Attorney General is created by the Constitution of India. Article 76 does not mention about Solicitor General and the Additional Solicitor General. So the Attorney General is not a member of the Central Cabinet. He is a separate law minister in the Central Cabinet. So this is about the Attorney General of India. Now I am coming to discuss about the Advocate General of the state. The Constitution, Article 165, has provided for the office of the Advocate General for the state, and he is the highest law officer of the state. And appointment and term, the Advocate General is appointed by the Governor. Likewise, the Attorney General is appointed by the President. Here, the Advocate General is appointed by the Governor. He must be a person who is qualified to be a judge of a High Court. He should have held judicial office for at least 10 years. He should be, he may be an advocate of any High Court for 5 years, and he should be a citizen of India. So these are the qualifications in case of the Advocate General of the state. So the term of the office of the Attorney General or Advocate General of the state has not been mentioned by the Constitution, and nor does the Constitution gives any clear stipulations regarding the removal procedure, in what grounds and on what grounds, in which manner it can be removed. And he is removed by the Governor, or he can put his resignation letter to the Governor, and normally he resigns. So when the government is replaced, when the Council of Ministers altogether resigns, because he is appointed by its recommendation. So the remuneration of the Advocate General of the state is not determined by the Constitution, it is determined by the Governor. The duties and the functions of the Advocate General of the state: to give advice to the government of the state upon which the legal matters which are referred to him by the Governor, to advise the state government on such legal matters which are offered to him or which are conferred to him by the Governor, to perform such other duties of a legal character which are assigned to him by the Constitution, and to perform such other duties which may be conferred to him by the Constitution or any other law. So in the performance of his official duties, he has the right, he is entitled to appear before any court within the court of law within the state, and further he has the right to speak and take part in the proceedings of any house of the state legislature or their joint proceedings of which he is a member, but he is not entitled to vote. That is the one thing. So, and he enjoys all the privileges and all the immunities that are available to a member of the state legislature. So that is the Advocate General of the state. So this is the Attorney General of India and the Advocate General of the state. That's all. Thank you.